Everyone knows that recreational or medicinal use of marijuana is legal in some states but remains illegal at the federal level. And this isn't just a meaningless quirk of how our laws work. It's a complex statutory conflict that can get you into serious trouble even if you don't smoke weed. And with the current administration's speedrunning authoritarianism, the state versus federal law conflict is only going to get worse. So to help keep you safe from the man, you're probably going to want a good lawyer. Luckily, we found a great one. Here's criminal defense attorney and your best friend, Mark Lopez.
Thanks, Devin. Now I want to talk about one of the biggest legal misconceptions that puts innocent people in jail every single day. And that misconception is all about weed, the ganja, the devil's lettuce, wacky tobacco, motherfucking marijuana. So let's clear this up so you guys can blaze free with good vibes if that's your thing. Marijuana is illegal in all 50 states under federal statutes, despite the fact that many states have legalized recreational use or decriminalized it. Not understanding the nuances at play here or how to deal with the police when you're high or sober can mess up your life for decades to come. But fear not, because I am going to walk you through it. It's what friends do. Now, suppose you take a trip to Las Vegas. Marijuana is completely decriminalized there. You go into a licensed dispensary, you buy something legally, you use it legally, have a great time, and go back home to a state without decriminalization. Let's say Arizona. 2 weeks go by. You get in your car completely sober and you get into a minor accident. Or you get pulled over for something small, like speeding, a broken taillight, whatever. The officer thinks he smells something or just decides to investigate further. Now you're doing field sobriety tests. Maybe you're nervous and you don't pass. Remember, these tests are subjective, and so your fate depends on how the cop interprets them. But here's where it turns. They're going to detain you and pressure you into taking your blood. And what they're looking for isn't impairment, it's metabolites. THC breaks down in your body into 11-nor-9-carboxy THC. It's not psychoactive. It doesn't impair you at all. But it can stay in your system for weeks after you use cannabis. So now you're sitting there completely sober and your own body is giving the state evidence against you. There are states where the law says that any amount of a controlled substance or its metabolite is enough to be a crime. It does not matter when you actually ingested it. Arizona actually had this exact issue. Their law made it illegal to drive with any drug or its metabolite in your body, which meant in theory, someone could legally use marijuana, wait weeks, drive sober, and still be guilty of a DUI. So the Arizona Supreme Court had to step in and address this scenario. Arizona's DUI statute made it illegal to drive with any drug or its metabolite in the body, and prosecutors argued that this included non-impairing marijuana metabolites like carboxy THC. The court rejected this interpretation, holding the statute does not criminalize the presence of inactive, non-impairing metabolites. The court reasoned that interpreting the law that broadly would lead to absurd results, allowing the state to prosecute drivers who are completely sober and unimpaired, including lawful medical marijuana users. Instead, the statute was limited to substances capable of causing impairment. In other words, the mere presence of a lingering inactive metabolite is not enough for a DUI conviction in Arizona. But a lot of states have yet to see the light on how absurd this is and probably won't anytime soon. So you can end up in a situation where you did everything right and still get in trouble weeks later. What happens in Vegas does not always stay in Vegas. And if you happen to be in one of these states after a fun weekend in Vegas and you get into a car crash and the police get your blood, you will be facing a DUI for having a metabolite. You're not high, you just have the metabolite in your blood. And God forbid somebody is injured, that can easily become a felony where you're facing years in jail. If you happen to find yourself in one of these states where the metabolites equals a DUI, what do you do if you're pulled over? Well, I'm not your lawyer, but I can give you some best friend advice. Don't admit to smoking marijuana. Don't admit to taking gummies. Don't do any of that. Don't make the state's job easier in prosecuting you. If they get your blood, don't fight the officers on that. They're just doing their job too. But the absence of your confession, that might be a way for your attorney to attack the ability for them to get their blood. Or if they do get your blood, your attorney can kick it out. They won't have your confession to try to bolster their case. So please do not admit to wrongdoing, period. Definitely not in one of these states with metabolites equals a DUI. So remember, this is not legal advice from a lawyer. This is advice from your best friend that happens to be a lawyer.
Now, whether it's surveillance cameras or data breaches, it really feels like we're losing out on our right to privacy these days. Your cell phone number, home address, email address, private social media accounts, and tons of sensitive data are shockingly easy to purchase by anyone online. But malicious actors can't hurt you if they can't find you. So you can fight back and take control of your private information by signing up for today's sponsor, Incogni. Because Incogni wipes your personal information from the internet by searching the internet, reaching out to data brokers and websites directly on your behalf, and forcing them to remove your private information. If they resist, Incogni will take care of that too, because Incogni fights back. But what makes Incogni truly powerful in taking control of your privacy is the custom removals feature. It allows you to flag an unlimited number of sites where your data is exposed, and you can even have Incogni's privacy experts review and tackle the most uncooperative data brokers and people search sites. Now, I've been using Incogni for years now, and in that time you can see I've been on hundreds of lists, some of which had a high sensitivity score, meaning the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me in that time. Now, I could never do this myself, so thank you to Incogni for saving me weeks worth of work and adding me to over 40 suppression lists. And Incogni will continue to conduct ongoing removals because even if the broker removes your data once, they'd always collect it and publish it again. So if online privacy is important to you, give Incogni a try. If you scan the code on screen or click on the link in the description, you'll get 60% off their unlimited plan. Or you can try Incogni risk-free for 30 days. And if you do decide you want to keep it, you'll still get the 60% off discount so long as you use my code LegalEagle, all one word. So sign up for Incogni or I'll see you in court.
Let's start with the part that trips people up the most. Marijuana is legal now. Most people hear the word legal and then they stop listening. It's legal in my state is what people tell themselves when they walk out of a dispensary with a flower or edibles or a vape. But that's not how the law actually works. And that misunderstanding is sending people to court. Here is the problem. There isn't one marijuana law in this country. There's federal law and there's 50 state laws that don't always agree with each other. These layers don't line up. So what feels legal may not always be safe. Start with the state-to-state problem. You're in Illinois. You walk into a licensed dispensary. You show your ID. You buy marijuana completely legally under the Illinois Cannabis Regulation and Tax Act. You have a receipt. You have a bag. Everything feels above board. You get into your car. You drive back home to Indiana. Now you're committing a crime. Indiana Code 3548-411 makes it a criminal offense to possess marijuana, period. I've got clients getting pulled over at the Indiana-Illinois border for doing something that was completely legal 10 minutes earlier. And that's true for all of these borders. Go ahead, memorize them, because these are the states where if you partake legally at a bachelor party in Vegas and you happen to be traveling through, you could get a DUI, but that's just the laws of these states. I see this constantly. People assume that because something was legal where they bought it, it's legal where they are now. That is not how the law works. Your receipt from an Illinois dispensary is not a defense in an Indiana courtroom. In fact, it's going to be Exhibit A. Now, layer in the federal side and pay attention here. Under the Controlled Substances Act, that's 21 U.S.C. Section 812, marijuana is still classified as a Schedule I controlled substance. That classification means the federal government views it as having no accepted medical use and a high potential for abuse. It doesn't matter what your state legislature decided. The CSA is a federal law, and federal law sits above state law when federal jurisdiction applies. And federal jurisdiction applies in more places than people realize, like federal buildings. And if you live in federally subsidized housing, marijuana possession can cost you your home under the federal drug-free housing rules, even if you're in a state where it's fully legal. In national parks, cannabis is illegal on every trail, every campground, and every parking lot in national parks and forests. So you can be in Colorado, one of the first states to legalize recreational marijuana, and be completely legal under state law. But the moment you step onto federal property, state law does not protect you. Now, I know what you're saying, but Mark, do people actually get busted for smoking up in a national park? Listen, if the law is on the books, there's a risk. Federal rules in the parks haven't changed much since 1970. So if you're visiting a Rocky Mountain National Park this summer, you have to be careful. First-time offenders are often looking at smaller fines, maybe $150, maybe $350. But repeat offenders can face fines up to $5,000 and 6 months in jail, and a federal record that will follow you around for the rest of your life. And if you're not convinced that violating federal marijuana laws and national parks is going to be a problem going forward, take a look at who is now staring back at you on your national park pass. Go ahead, take a look. And don't assume a domestic flight between two legal states is safe territory. TSA operates under federal authority. What they find, they can refer for prosecution. The fact that Denver and Portland both allow marijuana is not a legal defense for what's in your carry-on. And it gets even stranger when you look at individual airport policies. Some airports, like LAX, effectively allow you to carry small amounts so long as you're within state law. Others go the opposite direction. Denver International Airport, for example, bans marijuana entirely on airport property, even though it's legal in Colorado. Las Vegas has similar restrictions, along with amnesty boxes where travelers can actually dump cannabis before going through security. So the rule isn't just federal versus state, it's airport by airport. The same exact bag could be ignored in one terminal, confiscated in another, and could get you cited somewhere else. So that's the illusion. You think the law changed because cannabis became legal, but what actually happened is that one layer of the law changed. That gap between layers is where people get arrested. The moral of the story is, know the layers. Know where you are, don't trust websites or ChatGPT, call a local defense attorney and just ask what the state laws are and what kind of things people get in trouble for doing. They are probably not going to charge you, and now you have a lawyer in your address book if you ever need it. Now, while it's true that criminal punishments for marijuana use and possession have lessened over the past few decades, the federal government can still strip you of your constitutional rights even when you use marijuana legally. It's messed up, but it's being challenged right now in the Supreme Court. And now, the fate of you being able to get lawfully lifted without the risk of losing your rights may come down to, and I swear I'm not making this up, how often Thomas Jefferson got shit-faced drunk. So, here's a question the Supreme Court is actually wrestling with right now. If you take one THC gummy every other night, can the government take away your guns? The case is United States v. Hemp-derived. Here's what happened. The FBI searched a home in Texas. They found a gun and some marijuana. The guy, Ali Hemp-derived, admitted he smoked weed every other day. Prosecutors charged him under a federal law that says if you're an unlawful user of a controlled substance, you lose your Second Amendment rights. Full stop. The district court threw it out. The Fifth Circuit agreed. Now it's at the Supreme Court. And here's the thing, the justices are not buying what the government is selling. Under precedent from New York State Rifle and Pistol Association versus Bruin, the government doesn't just get to say a gun law is a good idea or that it promotes safety. It has to show the restriction is consistent with this country's historical tradition of firearm regulation. Basically, what kind of limits existed around the time of the founding. So in a case like this, the question isn't just whether marijuana users might be dangerous, it's whether there's a real historical analog for taking away someone's gun rights based on that kind of status in the first place. The federal government argues that people who use drugs regularly are dangerous, and dangerous people can be disarmed. They point to historical laws that stripped gun rights from, and this is the key word, so remember it, habitual drunkards. The logic is, same principle, different substance. Sounds reasonable until you poke it. And that's why Justice Gorsuch came loaded for bear. He pointed out that the founders themselves were not exactly sober.
John Adams took a tankard of hard cider with his breakfast every day. James Madison reportedly drank a pint of whiskey every day.
But by the standards of the day, these guys weren't considered habitual drunkards.
Habitual drunkard, the American Temperance Society back in the day said 8 shots of whiskey a day only made you an occasional drunkard. We have to remember the founding era if you want to invoke the founding era. To be a habitual drunkard, you had to do double that.
So Gorsuch asked, if that's the historical baseline, what exactly is the problem with Hemp-derived smoking weed every other day in unspecified amounts?
We know he uses marijuana a few times, about every other day. That's all we have in the record, right?
That's all we have, and I'm
Okay,
not troubled by it.
so we don't even know the quantity of how much he uses every other day. What if he took one gummy bear with a medical prescription in Colorado? Well, you may not even need a medical prescription. You don't even need that anymore. But let's say he had one to help him sleep every other day. Disarm him for life?
Well, no, it's not disarm for life, and here's what's going on.
Potentially.
Well,
Would that be enough under your theory? One gummy bear every other night with a medical prescription.
so I think you'd have a potential rehave problem, but I will accept the hypothetical. So let me just deal with
I think
what's
the answer
an
is
unlawful
yes.
user.
Here's the kicker. The federal government cannot even define what an unlawful user is.
One, you asked about how do you tell who's an unlawful user? How is it more defined than a habitual drunkard? I think it's a lot clearer.
Is it? I mean,
yes.
the government has not been able to define what a user is. I mean, it is said at various points that it's someone who's used any illegal drug in the past year, right? It's said, ATF now wants to say a pattern. And you argue for habitual, which of course conflates the second half of the statute, which talks about an addict, which is different than a user, and an addict is an habitual user.
Let me be very clear about the distinction here. There is a distinction between what is the statutory definition of an unlawful user, and everyone has always agreed, including ATF, that that means habitual or frequent. And on the other hand, how do you prove that? What type of evidence is sufficient to show beyond a reasonable doubt, or for purposes of background checks for ATF purposes, that you in fact do that? So
okay,
that
so
is the discrepancy.
circles us back down to you would qualify as an habitual user, one gummy bear every other night.
Gorsuch's point is there's no clear line. Use it at parties and keep your gun locked at home. Are you covered? Nobody knows. The statute doesn't say. That's not law. That's a trap. Gorsuch also pointed out that the government is currently considering downgrading marijuana from a Schedule I to a Schedule III. Under the government's own theory, that would make the pot not dangerous enough to justify taking your guns. So, what are we even doing here? Gorsuch was essentially asking why the government picked this case with this drug right now. The government didn't have a great answer. Justice Sotomayor piled on, noting that Congress never actually studied whether marijuana users are more dangerous.
I think the government gave this away when it said that there was no determination by the legislature on the dangerousness of the drug with guns in terms of listing it on the schedules. So doesn't that give away the whole game for that?
I think it goes to show why this court would have to do, or a court would have to do its own inquiry, because the bare
But
fact—
why bother? Meaning, if Congress, we can only uphold the law if there is something to defer to.
Correct.
But if no one has actually done the analysis whatsoever.
Justice Sotomayor's point was simple. Congress never actually studied whether marijuana users are more dangerous. They just put it on a list. They're in the process of taking it off that list. And yet, that list alone justifies taking away a constitutional right, maybe forever. But the direction is clear. The court is skeptical that using marijuana occasionally with your gun locked up at home makes you the kind of person the Second Amendment allows the government to permanently disarm. And that is great news for everybody that likes to partake, whether you're in Michigan, whether you're in Nevada, or in any state where marijuana is legal. Now, if you feel the government hasn't overcomplicated this enough, it gets worse. Because we need to talk about hemp-derived THC like Delta-8 and Delta-9. You know, the stuff they sell at gas stations in candy bars and drinks. I've had clients ask me straight up, as long as it's being sold over the counter, it's obviously legal, right? And the answer is, very lawyerly, it depends. So we gotta talk about hemp, the plant all of these products come from. You can think of hemp as the non-intoxicating cousin of marijuana. Back in the day, they used it for everything. Sails, paper, textiles, ropes. Colonial farmers were encouraged and even legally mandated to grow it. But the government banned industrial hemp in 1937 because of reefer madness.
Marijuana, the burning weed with its roots in hell.
Which brings us to the 2018 Farm Bill, a federal law that finally legalized industrial hemp again. Let's hear it for Congress. It only took them 81 years to make this right. Congress defined hemp as any cannabis plant containing 0.3% or less Delta-9 THC by dry weight. Anything above that threshold remained a controlled substance. It seemed like a clean, simple line, but it wasn't. What lawmakers failed to anticipate was that cannabis contains dozens of THC variants beyond Delta-9. Delta-8 THC, for instance, occurs naturally in hemp, but only in trace amounts. You can't smoke it and get high. But then you had chemists, these smart Walter White guys, who quickly realized it could be synthesized and converted from one legal compound into a psychoactive one. And because the Farm Bill never mentioned Delta-8 by name, and because it derived from federally legal hemp, it existed in a legal gray zone. That same logic eventually extended to Delta-9 products. As long as a gummy or tincture stayed at or below 0.3% Delta-9 by dry weight, it was perfectly legal on its face. And courts started recognizing it. In AK Futures LLC v. Boyd Street, the Ninth Circuit looked at this exact issue and said the statute is clear. Hemp included its derivatives and cannabinoids so long as Delta-9 THC stays below 0.3%. That means Delta-8 THC derived from hemp qualifies as legal hemp under federal law, even though it's psychoactive. So now you've got products that absolutely get people high being sold in places that were never part of the marijuana regulatory system, like Circle K. And the rules, they're all over the place. Some states allow it, some states ban it, some are trying to figure it out in real time. And good old Congress is still trying to rewrite the Farm Bill to ban Delta-8 and 9. I guess there's nothing else they have to worry about going on right now. For now, Delta-8 remains legal in 22 states and Washington, D.C. So we've got marijuana that's legal in some states and a federal crime in others. We've got metabolites in your blood weeks after you sobered up. We've got psychoactive products at the checkout counter at your local convenience store. And the law can change when you step in and out of the post office because you could be in the parking lot totally fine smoking up. But the moment you step into federal property, you risk the chance of going to jail. Now, I'm not all doom and gloom. The reality is, in the United States, the trend is towards legalizing marijuana. And I do think within 10 years, we're probably going to have it legal across the entire country. But it's not there yet. Know your rights. Don't admit to a police officer you've smoked up or you've done any drugs. And from your best friend who wants only the best for you and to keep you safe, always plead the fifth.
Now, all this highlights why it's so important to get a great lawyer when you're dealing with your own case. Now, after I started this channel, every week I'd get hundreds of comments and emails from viewers who are dealing with legal problems. And they'd ask, can you help me find a lawyer? Or how do I know if this attorney is any good? And there's a massive gap in our justice system. It's that people don't know how to find the right lawyer for their specific situation. They're scared, they're overwhelmed, and they end up doing nothing or hiring the first attorney who calls them back. And that really bothered me. So I started to wonder, what if there was a different way? What if we could build a law firm that actually lived up to the values that I talk about on this channel? Transparency, accessibility, and putting clients first instead of chasing billable hours. A firm where you don't need to pay anything up front and your lawyers only get paid if you do to maximize your opportunity for justice. So a few years ago, I decided to fix that problem. I decided to start my own personal injury law firm. And honestly, it wasn't an easy choice. But I realized I was in this unique position. I had this platform, this community, and the experience. Not to get rich, trust me, there are easier ways to make money than starting a law practice. But we did it because access to justice shouldn't be a luxury. Because finding the right legal representation shouldn't feel like playing Russian roulette with your future. And when you work with my firm, you're not just getting a lawyer. You're getting a team that understands that behind every case is a real person with real stakes. If we can't represent you or you're in a state where we don't practice, we'll take the time to try to match you with an attorney in my personal network of lawyers. A national network of some of the best lawyers in the country who actually specialize in what you're going through, located right where you are, not just whoever happens to be available. So if you're dealing with a personal injury, a car crash, a data breach, sexual harassment, a social security or workers' comp issue, give us a call at the number on screen or click on the link below. Now, I can't represent everyone that watches this channel. I wish I could, but what I can do is make sure that when you need legal help, you have somewhere to turn to that you can trust. So whether it's me handling your case or the incredible attorneys we partnered with, you'll get the same principles of honesty and education that we bring to every video. And if you're dealing with a legal issue and you're not sure where to start, check out the link in the description. Let's have a conversation about how we can help you find not just a lawyer, but the right lawyer for your situation. Because at the end of the day, that's what this is all about, making sure that when life gets complicated, you don't have to face it alone. Which is why when you need a lawyer, you don't just need a legal team, you need the Eagle team.